Welcome back. This is The Firm. Earlier this month, The Firm deviated from law to talk about the consequences of a depreciating rupee and a deteriorating economy. With over $200 billion in foreign borrowings, many Indian companies could face a serious risk of default if the rupee continues to fall. Fortunately, 2013 is not a big year for FCCB redemptions, because if it were, defaulting companies could face a losing battle in court. I say this because after the 2011 victory against Wockhardt, foreign bondholders have been on a winning spree. Zenith, KSL, Shivwani, Mozaber, all these companies have been successfully litigated against by their bondholders, and there are more in the pipeline. Payaswini Upadhyay finds out what this new credit hierarchy means for companies, their secured and unsecured lenders.
In 2011, the Wockhardt case marked nothing less than a revolution for the Indian financial world, as unsecured creditors successfully asserted their rights for the first time. The financially beleaguered pharmaceutical company was in the throes of a corporate debt restructuring process initiated by its secured lenders. Excluded from the CDR, a few unsecured FCCB holders filed a winding-up petition against Wockhardt in the Bombay High Court. Their intent was to block the sale of Wockhardt's nutrition business to Danone until their dues were recovered. The court agreed, forcing Wockhardt to repay bondholders or face liquidation proceedings. For the first time, unsecured creditors jumped the queue.
Before the Wockhardt judgment was pronounced by the Bombay High Court, these bondholders were not being quite well entertained in the CDR process, and they were not happy with the CDR process that was going on, and they basically felt that the CDR process would only extend the rights of the existing secured lenders and leave them further behind in the queue in case the company became insolvent.
And what is the right we're talking about? It was not right of recovery. It was a right that if a company claims it is unable to pay me as a creditor, why should the company be allowed to survive? That is the right we're talking about, and that's what Wockhardt is really about. People see Wockhardt as, oh, unsecured creditors, got paid out. That's not the point really. The point was, if a promoter or some of the creditors claim that it's okay not to pay the unsecured creditors but pay us and continue in existence, that is where Wockhardt comes up.
The corporate debt restructuring process is an informal process devised by the RBI and run mostly by Indian bank lenders. It often envisages the sale of a company's assets in order to repay the secured creditors. The CDR format does not include unsecured creditors, which is why unsecured creditors such as bondholders have often gone to court to file a winding-up petition against a company and thereby block a CDR unless their demands are also met. It worked in the case of Wockhardt and in the case of Mozaber and Shivwani as well. Oil and gas company Shivwani defaulted on its FCCB obligation, prompting the bond trustee Citicorp to file a winding-up petition in the Delhi High Court. 2 weeks ago, the court restrained Shivwani from implementing any CDR scheme. 4 days later, the court relaxed its order to allow Shivwani to undergo CDR, but on the condition that any fresh rights created in the company's assets will need court permission. A similar battle played out between Mozaber and its bond trustee Citibank. With unpaid dues of 688 crore rupees, Citibank filed a winding-up petition against Mozaber in the Delhi High Court last year. In December, the court restrained the company from alienating any of its assets. But the company's secured lenders argued against a winding-up and in favor of a CDR and committed to a debt haircut. The court subsequently allowed Mozaber to continue with the CDR process, but on the condition that any sale of assets will require court approval.
We have to understand that the purpose of the unsecured creditors, bondholders, is not to prevent the CDR process. That's not what they want. The courts are also not looking to prevent the CDR process. What they would, however, like is that if there is a CDR process, and the secured creditors want to confine it to themselves and not look after the interest of the unsecured creditors, then the unsecured creditors have certain remedies in law.
The spate of bondholder victories has caused some companies to deploy new tactics. Last year, after Zenith Infotech failed to make a 586 crore rupee FCCB redemption, its bond trustees filed a winding up petition in the Bombay High Court. After several months of twists and turns, while the matter was pending decision, Zenith filed a reference with the Board for Industrial and Financial Reconstruction or BIFR asking to be declared a sick company. Bombay High Court's Judge Kathawala frowned on the tactic, saying the principal object of the SICA is to rehabilitate genuinely sick companies where due to factors beyond their control, the companies have become sick, and that the Act is really not meant to help those companies where the company has become sick due to dishonesty, siphoning of funds and misappropriation of funds by its promoters and management.
Some of the high courts in the country have become sensitive to this and are more conscious about when they're granting adjournments as to how it is being done. At times they just ensure that the oral undertaking is given that this doesn't mean you will go and make a reference to SICA and defeat the whole purpose. Or at times they're expediting the hearing on the basis when they realize that the process of the court is being abused to make a reference to SICA and to defeat the whole purpose.
Justice Kathawala ultimately decided not to interfere with the BIFR process, but not without saying, "I'm also conscious of the fact that such dishonest promoters of the company take advantage of a beneficent legislation like SICA." A more recent member of the club of successful unsecured creditors is Bank of New York Mellon, a trustee for KLG Sistel's bondholders. After failing to recover dues worth 130 crore rupees, the American bank filed a winding up petition against KLG Sistel in the Punjab and Haryana High Court. In May this year, it emerged victorious.
Courts, as I said, would use winding up as a matter of last resort. Having said that, if the company is obviously delinquent in its finances, the unsecured creditors frankly have no other option but to pursue a winding up of the company, primarily as a pressure tactic, as I said. Now, the secured creditors, for them, it doesn't make any sense to cooperate with the unsecured creditors because their interests are completely different. To that extent, there won't be any synergy between those two groups as such. But the courts increasingly will be more and more forceful on the borrower.
Wockhardt, Zenith, KLG Sistel, Mozaber and Shivani. These are the cases that have reached some results in favor of unsecured creditors. The pipeline has many more. Tulip Telecom is facing winding up proceedings in the Delhi High Court filed by Axis Trustee Services that holds 84 crore rupees worth non-convertible debentures on behalf of the company's bondholders. Winding up proceedings against Sterling Biotech are ongoing in the Bombay High Court after it failed to pay its bondholders last year. Bondholders are fighting a similar battle against ICSA in the Hyderabad High Court. Geodesic has defaulted on dues of $113 million and currently has winding up petitions filed against it by Standard Chartered, Citibank London Branch, Barclays and HDFC. Suzlon, Sakti Sugars and S. Kumar have been served legal notices by their respective bondholders asking them to pay up or face winding up proceedings.
Why is it that CDR doesn't deal with the promoters? Why is it that the CDR doesn't really make promoters do meaningful sacrifices, including write down of shareholding, etc., or change of management? And that is what the biggest objection of the unsecured creditors, especially the bondholders, has been. That you are asking us to take a huge haircut, wait for 10 years before we get paid, but you are allowing the very people who have created the problems. See, it's one thing to say economic conditions are such world over, but as some of the instances which have happened in the last few years will show clearly, it's the promoters who have siphoned off funds or who have been reckless in their way they manage the companies, etc. But the secured creditors still keep giving them a further chance at the cost of the unsecured creditors. I think that will change. At least some of the securitors we have been talking to are conscious of this fact now that, okay, the days of taking the unsecured creditors for granted, the days of giving promoters priority over unsecured creditors are coming to an end.
Add to that the promise made by the Companies Act 2013 that envisages the formation of National Company Law Tribunal or NCLT. Once set up, the NCLT will exercise the powers of BIFR under SICA and the winding up power of High Courts. Since all the proceedings of a defaulting company will take place under NCLT's roof, the hope is it will reduce the abuse of court process that Jayesh spoke of. But since that will happen in due course, for now, the unsecured creditors are asserting their rights like never before. In Mumbai, Paiswini Upadhyay.
With that, we're entirely out of time. Thanks very much for watching. We'll see you next week.